Good evening, everyone. Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are here today with the attorney Prashanthi Reddy to discuss latest updates on immigration, FAQs on H1B and other immigration matters. You can call in the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in few minutes. Before that, I would like to repeat the disclaimer. Please note that this show is not intended to provide any legal advice. It is very general in nature and it is only for informational purposes. So Sakshi TV News or agents are not responsible in any way for your actions. Please use your information at own risk. Also, if you have to reach the attorney for private consultation, please reach Prashanthi Reddy at 212-354-1010 or prashanthi@reddyesq.com. Hi Prashanthi Garu, how are you doing?
Hello, Andy. How are you, Ranjit?
I'm good. Thanks for asking. So yeah, we have a few important topics that we can discuss. Meanwhile, waiting for the calls. The first topic I would like to ask you is about the USCIS recently sent an update or updated the portal saying that they are extending the timeline for the response of RFEs or MTRs or something like that. Could you please explain about it?
Right. So the first thing they did, USCIS did gave some benefit or some, they gave some leniency with reference to cases after COVID. Once COVID hit, there were a lot of changes made to make it easier for people to file, and so one of their benefit was that they said that there would be an automatic extension of the deadlines. So any kind of deadline, anything that had a deadline, for example, a request for further evidence, a motion to reopen usually has a deadline, a notice of intent to revoke, notice of intent to deny, and even audits have deadlines. So for everything, basically, they have said that they will extend the deadline, and they did it until for any cases between March and September that were filed between March and September. Now they've extended that further because September is almost over. They've extended that further to January of next year. So any RFEs that we receive within this period of time, you automatically have a 60-day grace period to respond to that RFE. So they will only issue a decision on the case after that 60-day grace period is over. So which means that if you have a H1 and there is a request for further evidence, if you're not able to respond by that date given on the RFE notice, you have extra time to respond in case, for some reason you're not able to respond on time. So that's good news for all of us because we were worried that September is coming and the deadline, and that that will lapse that benefit, but they have extended it. So especially in this time, I've noticed a lot of people are finding it difficult to manage deadlines and to respond on time for various reasons, due to illness, due to family members, getting ill, or because they're out of the country, or because they've lost their job, or whatever reason it might be. Now we have additional time, so that's a great benefit that is being extended.
Okay, that means earlier RFEs used to have, I believe, 90 days, which is 3 months, and now it's going to be 5 months or 60 days more.
Right. But we don't take that for granted. We usually respond within the time given to us in the RFE. There's no reason to go beyond that, but under, extraordinary circumstances, if we have to, then we have that cushion. So always try to respond within that period of time that is given to you. And if you're not able to for some reason, just treat that as a cushion, but don't treat that as a new deadline. That's not a good idea. So just, follow the deadline given to you in the RFE.
True. Okay, another recent update that happened is, one of the courts stays on the preliminary injunction of public charge rule, which has been lifted because of pandemic for some, I think for most of them. But then could you please update on that?
Yeah, so this public charge rule has been a seesaw. It's been going up and down. They've removed it, then they put it back again, then they again removed it. So basically, just to backtrack, under the present administration recently, they've expanded the public charge rule. So basically, public charge rule is always there. It means that, before giving someone a green card, this was only applicable to green cards. Before giving someone a green card, they wanted to make sure that, you will not become a public charge, and you will not, a lot of people would take green cards and immediately go on welfare. So they want to avoid, that, they want to avoid that scenario. And they're trying to make sure that you don't become a public charge. But it was very limited in the sense that you did not have to show in the future that you won't become a public charge. You just have to show that, you did not take any specific public benefits, such as welfare and food stamps in the past, and you have to show that someone is willing to, your sponsor is willing to basically, pay for any other, of your expenses so that you don't become a public charge in the future. But now then after that, recently they extended that public charge rule. They've extended many welfare benefits given, which were previously not under the rule. They've extended that. So a lot of benefits have been extended. So be careful when you take some benefit, make sure that it's not in the public charge rule, because the scope of that has increased. Number one. Number two, the other change that we see in the new public charge rule is that even H-1Bs, non-immigrants, have to show that, they have not, at least they have to show, and they've changed the I-129 form, and they have to show that they've never been on public assistance before. And of course, green card holders, the scope is much more varied, much more broader. And also they have to show, for people who are applying for a green card, that in the future also they will not become a public charge. So in order to show that, it's the officer has to, there's a new form that has been added to the 485 adjustment of status form. A new form has been added, and there are a lot of questions in that form as to, what is your income, what is your job, what is your education. So they want to make sure that once you come here, you have a job and you are basically employable and you don't become a public charge. And so what they look at is, previously they would just see if the sponsor has an income above the poverty guideline, which is 25,000, for a family of 4, which is not much. As long as they had that, they would approve green card cases. Now they want to make sure not just the petitioner, they want to look at the actual applicant's finances as well. And they want to make sure that the applicant will not become a financial burden on the United States. So they have to look at the overall picture, and they look at whether that he or she is employable or not, whether they've ever taken benefits in the past, whether they have any kind of health issues which will force them to maybe take some kind of benefit in the future. So they look at everything. At the interview, everything is looked at. All the documents are looked at, and they then get to decide whether the green card should be given or not. So that was a big deal. And we were filling out these additional forms, and it's especially hard for people who are, coming into the country on a green card, because when you're filing from abroad and coming in, because it's really hard for them to show that there won't be a public charge in the future. Also in cases where, you're filing family-based, such as the spouse is filing, and if the spouse is not working, and then the alien spouse is outside the country and therefore doesn't have any financial record in the US, it's really hard in that situation. So we were having to show all these other, additional documents. But then what happened is a court, the district court, a lawsuit was filed against this public charge law, and a district court put an injunction on the public charge rule. And they basically said that for the interim time that it is not decided, that it is pending in court, we are placing an injunction, a temporary hold on implementing the public charge rule. But then recently, Federal District Court has said that the injunction is null and void, and an injunction cannot be placed. So they have actually removed that injunction. And so USCIS is now free to implement the public charge rule again, and this is only recently, I believe last week. So, but USCIS has, as of now, not said anything as to whether they're implementing it or not. Maybe they're waiting to see what happens on the merits so that they don't have to keep, going back and forth, because already twice, I think, they've gone back and forth on the public charge law. Removing it, implementing it, removing it. So maybe I'm hoping that just on their own don't want to implement it now because they want to see what the final outcome will be for the court case. So as of now, we still don't have it, but they can, now they are free to implement it at any time that they want.
Got it. To extend this conversation, USCIS recently also, published a memo kind of saying that they'll enforce sponsor accountability for reimbursement of public benefits. So what does this mean? So whoever is guaranteeing or sponsoring, the money for a green card, so are they going to hold them accountable?
Yeah, so what they're saying, so they're always supposed to be accountable, but it was never implemented. I have never seen a sponsor being, held accountable. So basically, as I was saying, the public charge rule, we were talking about the holding the sponsors accountable. So when you file a green card for someone, you have to fill out something called an I-864, which is an affidavit of support. So you're basically swearing that you will support that person and you will not allow them to become a public charge. So that is usually done by an immediate family member or someone close to you, or it could be done by a family member or even a friend. Anyone can really file that affidavit of support. But in the past, it was never implemented. Another situation in which the affidavit of support is filed is when you're filing for a B2 visa or an extension. Someone has to file the I134, which is the affidavit of support for non-immigrant petitions, saying that you will not, overstay, you will not be, again, take benefits that they will provide you with. In the affidavit of support, they clearly have to mention what they will provide you with. And usually it's food and lodging and, will cover expenses. So if they see that a non-immigrant is like a visitor's person is, for example, goes to emergency care, to an emergency room because of a health issue, and then obviously does not have health insurance, they will hold that person, maybe your friend, whoever filled out that affidavit of support for you, and then the hospital can go after your friend for the hospital bills, which could be a huge amount of money, depending on what your health situation was. Any emergency visit will not be less than thousands of dollars, no matter what you actually go in for, even if it's a minor, smallest of things. And the same thing with the affidavit of support for the green card. If you get a green card and then you go on Medicare, or you take food stamps or something else, then that agency which is providing that can go after that person who signed the affidavit of support. So this is quite major because there was never any memorandum or clear guidance on what is the obligation of a sponsor, but now they've come up with this, so don't fill out an affidavit of support.
I think Pooja is online again. Hi Pooja, can you hear me?
Yes.
Yeah, you go ahead. You are on air and you can ask your question.
Okay. So my current H4 EAD is in renewal process, and I am working, and my current H4 EAD will get expired on 30th of September. So while my renewal is in process, can I take unpaid leave of absence?
Yeah. So while your renewal is in process, you obviously cannot work. So you cannot be on the payroll of the company. So you have to ask your company, because it's an I-9 issue, but I don't think you can take a leave of absence. They have to take you off the payroll completely because you have no authority to work. and they'll have to take you off the payroll and then put you back on the payroll. Whatever that involves. So my understanding is unpaid leave is they're still on the payroll, but you're not being paid anything. But I think in this situation, they have to actually take you off and then put you back on, do a fresh I-9 for you. It's like a fresh hire, basically.
Okay. Thank you.
Okay, Prashanthi, to add to what you were saying, so what if, few people have accrued some vacation or leaves or, something like that when they are, when they have been working for quite some time. And let's say in this scenario, what Pooja was saying, if she had some accrual of vacation or sick leave or any sort of that leave, is it okay to use that and get paid because that's something she has accrued while she was working?
Right. Yeah, correct. So if you accrued it already, if it's only the question of getting paid, the benefit was accrued while you were still on H4 EAD status, and you're just getting the check now, that is fine, because the pay period will be for a previous period, for previous employment. That has already passed. So as long as right now you're not on the payroll, you're getting a check for it's like a severance paycheck. You're allowed to get a severance paycheck even after you leave the company. It's the same thing. So that is fine. But you cannot continue to be on, strictly speaking, there might be some companies that still do it, but strictly speaking, you're not supposed to be on their payroll if you don't have employment authorization.
So basically, they have to be terminated and rehired again.
Correct. So they need a new I-9 to be filled out.
Okay.
But they can get a severance pay or back pay, or if there's any pay that is due to them. As you said, paid leave.
Usually when an employee is terminated, whatever the accrual of sick leaves or vacation leaves as per the company policy, they just pay out and they just terminate you.
Correct. So you can get that check.
So the other option, a lot of people are facing these H4 and EAD delays. If you are don't want to lose your job, because a lot of companies don't wait for for you to get the extension approved, which is very vague. You never know if you are going to get today, tomorrow, or after 5 months or 6 months, or you never get it. So if you are in such a situation, as we have been discussing it, you can contact Prashanthi Garu offline, and you can, or any other attorney, and file a Mandamus petition. That way, at least you get it faster.
Right. And just to expand on that, basically, Mandamus is a petition that you file with federal court. It's a constitutional right. Everybody has that right. And you're basically forcing the government to take an action that they're supposed to be taking, and take it on time, in a timely fashion. So here you're forcing the USCIS to give some decision. You can't force an approval. It could be a denial also. To give a decision on your case if it is beyond the processing time. But before you do that, make sure you have exhausted all your other remedies. Call USCIS, send them emails, follow up with them. Call your senator, local congressman. They always have an immigration department, all of them, all these offices. So they help by following up through their office. And also you can email the Ombudsman's office, and that is, you can just go to Ombudsman.
We have another caller, Prashanthi. Let's take the call and then we can continue. Okay. We have a caller, Ravi from North Carolina. Hi, Ravi.
Actually, Prashanthi, I have a question regarding my 140. My 140 has been approved with my old employer, and after that, recently I moved to full time. And I just got an email from my employer a week back stating that he wants to revoke my 140. I requested him for a week, so he is okay for a week, but I just want to find out if he revokes my 140, I can still use it, or I cannot use it. Is there any time period that I have to be employed with him?
Right. So if he revokes your I-140, you can use it for certain purposes, basically. So you can use it for purposes of maintaining your priority date. So you can keep your priority date, and you can file another I-140, labor cert and I-140. and keep that priority
Okay.
date, just transfer the priority date even after it is revoked by your employer. Also, you can use
Because
that for getting further extensions on your H1, again, even if it is revoked by your employer. But remember, it should not be revoked by USCIS for purposes of fraud. That's the only restriction on that. So as long as USCIS does not revoke it for fraud, employer revoking it does not affect these two things. Of course, finally, in order to get a green card, you will have to file another labor cert and I140 and then port the priority date in order to get the green card finally.
Yeah, I got it. But the thing is, I've been working with them for 4 years. But my 140, after my 140 was filed, after my 140 was approved, I was there with them for close to 4 or 5 months after my 140 was approved. So I was looking into for some forms, but I was not having any clarity. That because someone says after approval of 140, I have to be there for 6 months. Even though if they revoke the 140, I can still use it for future extensions. And because I've not completed 6 months is what I feel. And because next year, April is my 6 years maxing out. So my present approval is till April 2021. And because I have not completed my 6 months after my 140 is filed, just had that question, is that okay, or else is that something I have to complete 6 months after my 140 is filed with the same employer?
So there is no such rule that you have to complete 6 months after your I-140 is filed in order to get the benefit of using, your I-140 for the purposes of priority date or for the purposes of getting further extensions on your H1. That 6-1 rule is completely different. That is the AC21 rule for specifically if you have filed a 485. Then the 6 months, if you have spent 6 months after filing the 485, after the duration of 6 months, you can then transfer your green card to another employer. That 6 months is different and people often get confused. So there is no such 6 months for this particular aspect of what I'm talking. Once it's approved, you're allowed to keep it.
Okay, yeah. So is there any way I can get the receipt number or the approval copy, because I'm sure my employer is not going to share it to me, because I have time till April, because my next extension is I have to file before April. So is there any way I can get the receipt copy or the approval copy?
Well, your employer is supposed to give it to you, but sometimes they don't. And oftentimes, it makes sense to ask them immediately after the approval to at least give you a copy, because after you leave, obviously then they're not going to give you a copy because, right, you have to ask them. Did you ask them for it? That's the best way of getting it. Have you requested for it?
Yeah, I've requested it when I was employed with them. They told they're going to send it out this week, next week, and slowly they mentioned the pandemic came up and no one is in the office, no one is going to office. They had that reason, and slowly I got my full time where I was working with the same client and they were holding me for a long time. And once the pandemic came, they had a choice. I don't have a choice because they said if I'm not taking the full time, I have to. They are going to fire me. So I've just opted for a full time. And then I tried reaching my employer. He was not responding to me. Is there any way I can call USCIS and?
No, unfortunately, you cannot call USCIS because they will not give you a copy. But recently, there has been some change with reference to which party is entitled to, the I-140 information. And there has been a change last year. And they said the beneficiary also has a limited right on the I-140 information. For example, if there's an I-140 RFE and they're no longer working for the employer, they can still respond to that RFE. They are a party. They have said earlier they were never a party to the I-140 proceedings, but now their beneficiary also is a party to I-140 proceedings. So I think one way of trying to do it is to try to do a FOIA.
Yeah,
and
FOIA,
see
that's
if,
what
and try to see if you are if you'll be allowed to become a party to it, because I haven't done a FOIA for an I-140 recently, but under the new rules, I think they might allow you to do a FOIA. There's no harm in trying because the fees is
a lot of people were successful in getting I-140. They don't send you the I-140 approval, but they send you the I-140 form with a receipt number and a stamp on it. So
right. You had showed me, I think,
Yeah.
Someone had showed me that, right? So
Yeah.
it's not an approval, but you, and the other way of doing it, the easy way, which always works, is that at least if you have the receipt, then you can just go online, print out your status online, and then use that to get further extensions or to extend your priority date. And it has always worked. We always do that, and it
Yeah. But
never
the
has
thing is here,
there been
a
an
lot of,
RFE in that situation.
I mean, a lot of
So that's
employees
another thing
have
you can do.
this. Yeah, a lot of employees have this thing that, a lot of employers don't share even the receipt number. I'm not sure if that's okay. If that's not okay, I don't know if it's okay, but a lot of employees don't even get the receipt number.
Yeah, unfortunately, H1s and I140s are completely employment based under the statute. So there's no obligation for them to share that information with the beneficiary. Even for the H1, the only part that they need to share is the I94, which is the bottom half, which they're supposed to tear out and give to the beneficiary. But otherwise, unfortunately, there's no leg for them to stand on, except recently where they've made beneficiaries, party to the proceedings, and that has given them some limited benefit. So I think doing a FOIA might be the best way, other than pursuing, at least try and get a receipt otherwise, and get the receipt and then,
Okay. Sorry to
for
interrupt.
the
Can I
purposes
go
of,
with one more question? One more
yeah,
question.
go
Even my
ahead.
new employer, where I'm going full time, even he wants to file. So because I heard, if I'm using the old 140 and we can still keep the same priority date. So if he wants to file, how do I, get this initiated? Is there any way I can get it initiated without my existing 140? Is there any way you can help me? I can ask my my company's immigration team, maybe can get in touch, because it's a small company where they don't have much H1B employees, very few employees H1B, and I'm the first person maybe that doing the 140. So they don't have a really big
Yeah, we can
immigration team or
definitely,
something.
we can file a FOIA request for you. And those,
Okay.
they might take some time, but, definitely it's not a difficult process. We can file a FOIA request for you. In the interim, try and see if you can get at least a receipt notice from the employer, even if he's not willing to give the, always try to use the easiest way, of course. And if that fails completely, then, we do a FOIA request, and at least the PD, the priority date, will be stamped on the, on the forms, and then we can use that. And even if you don't have it, we can always request USCIS to port the priority date. Just give them all the information, name of the company, name of the beneficiary, and they can look it up, because they obviously have the approval with them. They have the records of it.
Yeah, I'll talk to my immigration team and the HR team and see if they can connect with you, and if you can help me on this, that should be really appreciable indeed. Thanks for
Sure.
answering the questions
You're
patiently.
welcome. You're welcome.
Okay, yeah. So yeah, these are, a lot of people don't even get this information, especially, people even from India, where a lot of, Indian IT staffing companies, they apply for the H1B, but they don't even give any, receipt number or something, and they have to end up struggling for it. FOIA takes a lot of time, but at least the good thing is FOIA has become complete online now. You can just create an account, fill in the information, and upload respective documents like passport or something, and they can at least wait for a few weeks to get it.
More likely a few months, but yeah.
Yeah.
Yes, it is. It is a
takes
simple
longer.
process. Yeah.
Yeah, it could take longer at times, but yeah, at least, people who are suffering would have that option. You don't have to. Yeah, another recent announcement that USCIS made was that they have revoked a few visas. I mean, thousands of visas, or about 1,000 visas for of J1 students from China. So do you happen to know anything about it?
Yeah, so yes, we've heard about that. And this was basically under the presidential proclamation, which Trump signed, saying that, F1s basically from China should be looked into. He didn't say completely ban or cancel their visas, but this is the action that they've taken as a result of that executive order. They basically canceled all those visas for Chinese graduate students, etc. So I think it was something that was expected anyway. And they'll have to go, if they really want, they'll have to go and reapply. They've basically said that it's the reasoning for doing it is really just the tensions, I think, between the US and China, and they're worried about trade secrets, etc. So they're worried about Chinese students coming here, and perhaps, I don't know what really, but it's a lot of politics, of course. And there have been some incidents where there have been cause for concern. So they're viewing it as a security risk, not just as a result of the pandemic. That is, those travel bans are different, and this is completely different. So that's big news that so many visas got cancelled for Chinese students, and they'll have to all go and reapply now for visas. And with the elections, nothing is likely to happen. But once the elections are over, then depending on which party comes in, then we have to see what is the future for Chinese students, because a lot of universities do depend on students from China, just as they depend on students from India. There's a big, big chunk of students coming from China. So I'm sure the universities will have something to say in this as well.
We have one question from offline. So a lot of people are asking this: does job title really matter for the H1B, or because a lot of companies have weird job titles like analyst 1, analyst 2, associate 1, associate 2. Does job title really matter, or it doesn't really matter as long as the job duties are of specialty occupation and have a good SOC code or the wage level? So
USCIS has always said that when looking at specialty occupation, when looking at whether the H1 qualifies, the job qualifies for a H1 or not, they should not look at job title, but only job duties have to be looked at. But obviously, job title is always looked at, because that is the first step for them to scrutinize whether there's, whether the job is qualifies as a specialty occupation or not. For example, if you use a computer programmer job title, even if the duties are that of a software engineer, I don't think they're going to approve that case. That's immediately you're looking for trouble. So what I tell my clients is that, the job title that you give is an internal job title that you are giving to your employee. He could be working at a client site, several client sites, and have different job titles at each client site. So what is important is the title that you are giving. And often the same title, like you said, he could be working as a software developer, but he could have some title of developer QA or developer something else, so which is not clear as to what that means. But the client will give whatever titles they want. So I will always tell my clients to use, because you have to find the easiest way possible to get your H1 approved. So I always tell them to use the job title that is most likely to get a H1 approval, as long as you're not lying about it. The job title is such a generic thing that, like, for example, if you say software developer, it's so generic, and it'll apply to so many different kinds of developer positions or IT positions. But if you say IT consultant, you're immediately going to get the specialty occupation RFE, because what does IT consultant mean? It's way too generic for them to use. They want you to use something a little bit more specific. So yeah, first thing is to keep in mind is the job title. And the second is, of course, no matter what job title you use, if you use a software developer job title or an IT manager job title, but you have duties which are testing duties, which say test and QA, then again, they're going to send a specialty occupation RFE. And you can't change the duties later on. So it's extremely important to make sure that you use the right duties and the right job title. Now, in situations where you, for some reason, cannot use the job title that you want to, then it's still possible. Use, whatever job title that you have, as long as, even if it's generic, use the IT consultant job title if you have to, in a situation where you have to. Because some companies, they cannot change their job titles because they're big companies and they follow certain protocols. And then make sure in your duties that it is specific to the dot. that you are explaining exactly what the person does, and make sure that they are matching with the duties from the ONET or the Occupational Outlook Handbook. So if you do that, I think you should be good. Even if there is an RFE, there might be an RFE, but you can still overcome that by explaining what the duties are.
Also, how about the SOC code and the wage levels? How important are those? How do they analyze, and how do we have to be careful, or the employer have to be careful, or the employee have to be careful and suggest whatever is good? So could you please explain about it?
Yeah, so that goes hand in hand with the job title, really, the SOC codes. So more important is the job title. Then you look at what is the SOC code for that job title. So really we go by, so for example, if you say software developers, it could be software developer systems, system software, or it could be, software developer, analyst. So it depends on, really, I would just go by the job title and use the ensuring, the code for it, rather than doing it the other way around. Just follow whatever the code is for the job title. So focus more on the job title. And of course, in order to decide whether the job title is specialty occupation or not, you have to go to the Occupational Outlook Handbook and see what they say is the educational requirement for that job title. And for example, if they say that a bachelor's degree is required in computer science, then you're good, if it's an IT field. But if they say, for example, a bachelor's degree is required and they mention 10 different fields, for example, they say engineering, computer science, science, math, physics, then you're in trouble, because USCIS is now interpreting that when it's not a single degree, when the requirement is not a single degree, it's not a specialty occupation. They're saying it should be a specific specialty, which means a specific degree. So be careful of that, and make sure you choose the right job title. Now, if you don't, sometimes the Occupational Outlook Handbook doesn't always have every single job mentioned in there, right? Oftentimes those jobs won't be there because they don't, update all the jobs. So in that situation, you would look at the job duties that you have, and then try to match them as closely as possible to whatever is available in the ONET or in the OH. And so if it's at least 50% or more matching, then you can use one of those job titles. You can also use, there is a catch-all job title that you can use, or SOC code that you can use, which is, like for example, engineers, all others. So you can use that. That's what it's supposed to be meant for. But I would try avoiding that, because again, it's too vague. Again, you will get an RFE saying what does all others mean, and explain. So I would rather use a specific job title like a project manager, IT manager, software developer, systems software engineer, something like that, which is established and which we know and is tried and tested, as long as we can get the job duties to work and fall within those parameters.
Got it. How about the wage level? So because the FLC has level 1, level 2, level 3, is it okay if someone files in level 1, or level 1 is not at all recommended?
So 2 years ago, they sent out a lot of RFEs. USCIS sent out a lot of RFEs for all those cases that people filed under level 1. And traditionally, everything falls under specialty occupation, level 1 to level 4. So the wage levels had nothing to do really with specialty occupation if you look at the definition of specialty occupation as per the statute. But as you know, USCIS keeps coming up with new ways of stopping people from getting H1s or closing the gates, so to speak. So they came up with this new mechanism of denying cases by saying that if it's level 1, it's entry level, and therefore it's not a specialty occupation because the duties are not complex enough. So, I mean, they just twisted the language completely and added some of their own logic to that and said that level 1 occupations are not specialty occupations. Anything, even if you do a software manager position, it's not specialty occupation if you're using level 1, which is completely ridiculous. And there was a lot of backlash on that. And luckily, they seemed to backtrack on that. There was no memo or anything, but most of our RFEs that we responded to got approved that were level 1, and so we were successful. After that, I haven't really, after that year, last year, for example, I mean, people have become more wary also about using level 1, and I tell them not to. But in instances where level 1 is used, at least they're not sending out that language in the request for further evidence. They're not saying that, oh, because you're using level 1, we're sending this RFE. They might still send a specialty occupation RFE, but very quietly, without giving us the reason why they're sending it. They'll just send out a specialty occupation RFE. But so it's best to avoid level 1, but it's not as bad as that initial rush where they sent RFEs on every single level 1 case that was filed.
Got it. So before I ask the other question, I would like to repeat the disclaimer. Please note that the show is not to provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use this information at your own risk. Also, if you have to reach Prashanthi Reddy for a private consultation, please reach her at 212-354-1010 or prashanthi@reddyesq.com. So other question a lot of people have is, let's say if the I-94 is already expired and some petition is pending, like either H-1B or H-4 or any other petition. So, and unfortunately, if it's denied, do they have any grace period to leave the country, or they have to leave right away as soon as they know it is denied? So a lot of people
That's a great question. Yeah, because a lot of people get denials and then obviously if technically they fall out of status the next day. Because as per USCIS, the day the denial comes, you're out of status. But luckily there's some practical, though it's not in the regulation, the consulate and USCIS also follows, has a practical outlook to it. I mean, not to say that ICE can't come and pick you up once the denial comes and then you stay in the country, but you can always say that you are making preparations to leave. So even though there is no statutory period within which you're allowed to leave, or there's no grace period, statutory grace period, 60 days, 30 days, or anything like that, where you're allowed to stay and then leave. If your I-94 expires, for example, and the H-1 gets denied, then you have to leave immediately. But usually I would say it's reasonable to take a month or so to make preparations, month or 2 months. To make preparations to leave, you have to close your bank account. There's so many things that have to be done. And then when you go to get a new visa in the consulates, that will not be held against you. They will not say, oh, why did you take a month to leave? Why didn't you leave the next day? That I've never seen that happen. So there is some leniency in that matter, but we shouldn't take undue advantage of that. We should leave as soon as we possibly can. So that's what it is about. So the only thing to keep in mind is never stay more than 6 months. And that is, first of all, a long time to stay without any status. And also, if you stay over 6 months, then there's something called unlawful presence that comes into play. This was a law that was came into play in 1997. What it says is that if you are out of status, and if you stay in the US for 6 months out of status, or more than 6 months, then you are barred from re-entering the country for the next 10 years. That's the unlawful presence law. So even if the officer wants to give you a visa, he cannot, because he's prohibited from doing that as per the unlawful presence law. So just make sure it's never over 6 months.
Okay, got it. I believe I think in January 2017 there was a memo or regulation which says that they have people of E3, H1B, L1, O1 and H1B1 has a 10-day grace period that can be used when there is a denial, isn't it?
Right. So if the I-94 expires, you have a 10 days, 10 days that is added. Usually that is added to the I-94 itself nowadays. So you will see that the I-797 will have a different date. The period of the I-797, the end date period, will be different from your I-94 period, because they're automatically adding that 10 days grace period to your I-94. So be aware of that. Don't just add 10 days to your I-94, then it'll be 20 days. They're automatically already adding the 10 days. So when by the time you realize that you're out of status, most probably the 10 days is already over. So look at the date on your I-797, the end date, and you can add 10 days to that. Then you're safe. Don't automatically add 10 days to the I-94. So yes, there is a 10-day grace period that is added.
So another question here this is about CPT and OPT. So a lot of people say a lot of things, but how many times can someone use a CPT or OPT? Especially a lot of students, because of the scarcity of the H1B, is that few unfortunate cannot be able to use the H1B because they are not picked in H1B. So what they do, they pursue another masters. Some people take D1 CPT or some people take OPT. So is there something like you can take a number of times as you want, or if you say it's only one time per one level of degree, let's say only for the masters you can only take once, and for PhD again you probably can take another OPT or CPT or whatever. So are there any such restrictions?
Yeah, so originally, again, this is another classic example of USCIS changing its interpretation of the law midstream, just suddenly, without any regulation, without any publication of regulation or comment or anything. Just not even a memo. They just when you're processing cases, they just send out RFEs out of nowhere. So this is one of those classic examples of that. So originally, the way traditionally the law is and is written is that OPT can be taken only one time if it is the same level of education. For example, if you've done a master's, you've used up your OPT, then you do another master's, you cannot get another OPT. That has always been the law. But now they're interpreting or expanding that law to say that if you have taken OPT, done master's, taken OPT, then done another master's, you cannot even take CPT because you've already used up your OPT. So they're classifying the CPT and OPT as the same, when the regulation clearly says that only about OPT and doesn't say anything about CPT at all. So they're just expanding that. And recently, not so much this year, luckily, so far, but last year we did get a few RFEs where they basically said that you're on CPT right now, looks like you did a second master's, you cannot be in CPT, you violated your status, show us on what basis you took CPT. And even though we've explained the interpretation of the law is wrong, they obviously did not buy it because, they can do whatever they want unless you file another court case, against them. And they basically denied those cases. So the change of status portion was denied. But, luckily that time there was no pandemic, so they were able to leave the country and come back, on H1, even though, so the change of status didn't happen, but it automatically went to consular processing. It was approved for consular processing, and then they were able to come back by getting a visa. So this year, I haven't seen that interpretation. They have sent the usual questions on CPT, the usual RFEs on have you maintained your CPT, show us the correlationship between your CPT and the courses and the master's degree that you're taking. Why was it necessary to do a CPT, and show us that CPT is an integral part of your coursework. There's questions like that which they always ask on CPT. But luckily, so far, I have not received any RFEs saying that you cannot be on CPT because it's your second master. So let's wait and see what happens with reference to that. But it's always a risk when you're doing CPT. You can expect then the change of status might not get approved. And as long as you're able to leave and come back, it's fine. But, you know, it's always a problem. There's a lot of anxiety when you ask someone to leave because it's never guaranteed that they will ever be issued a visa on a H1. So there's always that anxiety and that risk that you're taking.
Got it. So it's always recommended that you use OPT, CPT, properly and not to get in trouble, especially when you are going to get on H1B. There will be a lot of queries, and it becomes complicated.
Right. So as you said, I mean, if you do have to take CPT, then it would be better that you take a PhD program. Then nobody can question whether, why you took CPT, because that is a higher level degree. It's not a second master's, it's an advanced degree. So then it's very clear, unless they decide to change their interpretation again, which they can if they want to. But yeah, it makes more sense than to do a PhD.
The USCIS always says that CPT should be part of the curriculum, and it should not be just, for the sake of CPT. So people have to make sure that CPT is a part of the masters you are doing, and it's just not that you need a work permit and you are just going for it. So PhD makes sense, as you said.
Right. So as you were saying, for example, if you're doing an MBA and then you take a CPT in an IT company and you're doing development work, obviously there's no correlation between the courses that you're doing, unless you're doing an MBA in information systems or something like that. If you're doing an MBA in finance or something and you do an IT job, then there's obviously no correlation. So in that situation, you will be in a lot of trouble.
Yes, especially, most of the master's programs or bachelor program, they have this CPT in the last semester only, because that's when the internship or the actual project is done. That's very well known all over the world that they only do it in the last semester. So if you are taking it from the first semester, obviously that's a trigger, that USCIS knows that, okay, hey, they are just doing, and obviously they would know that if it's your second master's or third master's, they would assume that you just wanted a work permit, so you have enrolled in day one CPT college. And I believe a lot of colleges are under the USCIS radar, and if you are pursuing masters in one of them, by default you would get the RFEs. So make sure whatever you're doing is properly and go through proper channels. As PhD makes sense because PhD is more of hands-on work, so having CPT on PhD makes sense.
Right. And then the other instance is if you're doing for example, a program where it's practical based program completely. So there are universities that offer curriculums like that, where the curriculum itself requires right from the beginning that you do that. It's completely practically oriented. I saw recently, I forget what it's called, but it's the whole curriculum. The way it's structured is that you are simultaneously learning in class and then you're performing a job with reference to those tools, and it's required in fact as per the curriculum. So that's how some of the universities are giving day one CPT also. So my take on that is, if you have a law, no matter what the intent of the student was in taking it, they have every right to, as long as they are within the boundaries of the law, to use the law as it is, But the only problem is that as it becomes systemic, like it has now, like with day one CPT, then USCIS suddenly wakes up and sees that, this is being misused. Then it's up to USCIS to change it, or to make, the Congress has to change it if they don't want that to happen. Then that'll be a big blow for universities, and the universities won't let that happen. So, that's all cyclic. So, and then, increase the H1B quota if you don't want that to happen, right? If you don't want people who have been educated in the US to leave the US because, they're so valuable, such a valuable asset, then, and everybody thinks of them as such, then you should do something with reference to the H1B numbers.
True, true. As always, the burden of proof remains on the petitioner. That way, if something happens, we have to end up doing thousands of pages of documentations, and we don't know if it's in our favor. And yeah, by the time we lose time, and that's why it's always better be careful than getting in trouble later. That's one thing. So another question we have is about now there was a second round of lottery for H1B. So a lot of people are asking, because of pandemic, because of various reasons, even the second round of lottery, whoever have been picked might not be able to file on because they don't have a project now, or they don't have a job, or already few people left, or whatever the reasons. Do you think there could be another round of lottery to fill those petitions? Because if there is, let's assume, not enough petitions being received by USCIS.
That won't happen because the fiscal year is getting over, right? October is when the fiscal year gets over, a new fiscal year starts. So they have to use up all those numbers before October. And since they're very cleverly given the deadline to file as November, by the time the deadline is over, the fiscal year will be over. So they cannot, it's not possible to have another lottery in that situation.
Okay, got it. Thanks, Prashanthi Garu. I think we are at the end of the show. I would like to again repeat the disclaimer. Please note that the show is not intended to provide any legal advice. It is very general in nature, and it is only for informational purposes. Sakshi TV News or agents are not responsible in any way for your actions. Please use information at your own risk. Also, if you have to reach the attorney for a private consultation, please reach Prashanthi Garu at 212-354-1010 or prashanthi@reddyesq.com. Thanks, Prashanthi Garu. It was very nice talking to you. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please keep calling us. Please call in every Wednesday at 6 p.m. EST to watch the Immigration Talk Show. Again, it's every Wednesday at 6 p.m. Eastern Time on Sakshi TV. This is Ranjit signing off. Thank you.
Thank you. Good night.
Good night.